name is Alexia Johnson, and I will be talking to you today about resolving ethical issues. The topics that I will be covering are reporting ethical violations, cooperating with ethics committees, improper complaints, and unfair discrimination against complainants and respondents. The first topic that I'll be covering is reporting ethical violations. If an apparent ethical violation has substantially harmed or is likely to substantially harm a person or organization and is not appropriate for informal resolution under Standard 1.04, informal resolution of ethical violations, or is not resolved properly in that fashion, psychologists take further action appropriate to the situation. Standard 1.05 requires psychologists to report ethical violations committed by another psychologist only if the violation has led to or has the potential to lead to substantial harm and informal resolution is unsuccessful or inappropriate. As a rule of thumb, behaviors likely to cause substantial harm are of a kind similar to sexual misconduct, insurance fraud, plagiarism, and blatant intentional misrepresentation. So, an example would be, let's say, a client reports to their psychologist that another client that was being seen is having a sexual relationship with a psychologist in the office or something. And that psychologist takes the information that that client gave them and assures them that they won't know who they are or whatever for reporting. They'll keep them a secret, and their identity is secret. Not that a secret, keep their identity a secret, and explain to them how it's unethical that that's going on or whatever. But they do all of that, and then they don't do anything about it, or they take it and report it. That's what you're supposed to do. Another example would be a psychologist writing something in a journal or something, and somebody reading it and knows that it's plagiarized in someone else's work. They'll take it to the chair or the board or whoever they're supposed to take it to, and they'll let them read it, and then they'll see that it's also plagiarized. And then the board is supposed to handle everything, and then they contact the journal or whatever that article or paper or something was published for, and they also let them know. That's how you would resolve those issues. Cooperating with ethics committees. Psychologists cooperate in ethics investigations, proceedings, and resulting requirements of the APA or any affiliated state psychological association to which they belong. In doing so, they address any confidentiality issues. Failure to cooperate is itself an ethics violation. However, making a request for deferment of adjudication of an ethics complaint pending the outcome of litigation does not alone constitute non-cooperation. A profession that demonstrates that it can monitor itself promotes public confidence in the service of its members. To ensure the validity and viability of APA ethics adjudication, I don't know how to say that word. Standard 1.06 requires that when called on to do so, psychologists cooperate with APA and state-affiliated ethics investigations, proceedings, and resulting requirements. During the comment phase of the ethics code revision, some members asked whether requiring cooperation with an ethics committee when a complaint has been brought against a psychologist raised Fifth Amendment issues regarding the right against self-incrimination. The answer to the question was no. Unlike state licensing boards and other government and judicial agencies, professional organizations are not bound by the Fifth Amendment. Standard 1.06 recognizes that when a complaint is brought against a psychologist, the ability to respond in full to an ethics committee request for information may be limited by confidentiality responsibilities. So an example would be, A patient submitted a complaint to the APA charging a neuropsychologist with misinterpreting the results of an assessment battery, leading to inaccurate diagnosis and denial of disability. To fully respond to the complaint, the psychologist needed to obtain the patient's written release so that the psychologist could submit to the ethics committee the test report and other information about the patient relevant to the complaint. Despite reasonable efforts, the patient refused to sign the release. The psychologist provided the APA Ethics Committee documentation of his request to the client and her written refusal, as well as a statement indicating how the client's refusal placed confidentiality limitations on his ability to fully respond to the committee's request. Standard 1.06 permits psychologists to request that an APA or affiliated state psychological association ethics committee delay adjudication of a complaint pending the outcome of litigation related to the complaint. If, however, the ethics committee declines such a request, failure to cooperate will be considered a violation of standard 1.06. The next topic that I'll be covering is improper complaints. Psychologists do not file or encourage the filing of ethics complaints that are made with reckless disregard for or willful ignorance of facts that would disprove the allegation. The filing of frivolous complaints intended solely to harm the respondent undermines the adjudicative, and public purposes of the ethics code. Examples of improper complaints to the APA Ethics Committee involve academic colleagues, business rivals, or psychologists with opposing forensic roles who attempt to misuse the ethics adjudication process as a means of defeating a competitor rather than addressing wrongful behavior, or who attempt to dilute a complaint against them through a counter-complaint. An example would be two academic psychologists, well known for conducting methodologically rigorous research on the validity of children's eyewitness testimony, were often asked to serve as forensic experts on opposing sides in criminal cases. The defense attorney, who had retained one of the psychologists for a highly publicized child abuse case, was concerned that a recent article published by the opposing psychologist would be potentially damaging to the defendant's case. At the attorney's urging, the psychologist submitted a complaint to the APA Ethics Committee claiming that the opposing psychologist had fabricated the data. The psychologist based her complaint only on the fact that the data seemed too good to be true. You can't do that. It's an improper complaint. There was motives behind that. So, it's not cool. Member groups of psychologists involved in adversarial proceedings are increasingly recognizing the need to address improper complaints. For example, the Academy of Clinical Neuropsychology has made the following recommendations for ethical and professional bodies considering ethical complaints made against neuropsychologists involved in adversarial proceedings. Ethical complaints should be examined after the resolution of related adversarial proceedings. Investigators should consider the motivation of those making the complaints. Investigative board members should be from different geographical regions and should have no prior relationships with those involved in the complaints and have expertise in clinical neuropsychology, and multiple unfounded complaints against the same psychologist should not be used to substantiate unethical practices where none exist. You can't make improper complaints. It's just wrong. The last thing that I'll be discussing with you today is unfair discrimination against complainants and respondents. Psychologists do not deny persons employment, advancement, admissions to academic or other programs, tenure, or promotion based solely upon their having made or their being the subject of an ethics complaint. This does not prelude taking action based upon the outcome of such proceedings or considering other appropriate information. Situations arise in which employees, colleagues, students, or student applicants accuse others or are accused of sexual harassment or other forms of professional or scientific misconduct. Standard 1.08 protects the rights of individuals to make ethical complaints without suffering unfair punitive actions from psychologists responsible for their employment, academic admission, or training. An example of this would be a student that was in a master's department being denied access to the doctoral candidacy or whatever, because she had filed a complaint, a sexual complaint, on a professor or someone that was on the member of their faculty. That makes sense. You can't do that. It's unethical. Standard 1.08 also recognizes that not all complaints have a basis in fact or rise to the threshold of an ethics violation. Therefore, the standard prohibits psychologists from unfair discrimination of individuals who have been accused of, but not found to have committed an ethical violation. Another example would be a therapist being accused by a client of misrepresenting a fee, and the other psychologists that were in that practice finds out and asks him to leave. The psychologist that the client reported or whatever, asked the psychologist to leave the practice. The use of the term solely in the first sentence of Standard 1.08 permits complainants or respondents to be denied employment, professional or academic advancement, or program admission for reasons unrelated to the complaint or for reasons based on the outcome of the complaint. Well, that's all that I have for you today on Resolving Ethical Issues Part 2. Hopefully you've learned something. I know I have. And thanks for bearing with me through this long, awkward process.
When your legs don't work like they used to before, and I can't sweep you off of your feet,